Welcome to the latest Evershed Sutherland Legal Insights podcast.
In the 9th episode of our Tech Talk podcast series, we explore how the important concept of legal privilege is being tested as employers increasingly adopt new AI tools across their organisations in a range of scenarios. My name is Hannah Mahon, and I'm a partner in our employment team. I also head up our employment AI workstream, and I'm the legal technology partner for the team. I'm now just going to briefly hand over to my colleagues and allow them to introduce themselves. So Matt, shall we start with you?
Thanks, Hannah. I'm Matt Chapman. I'm a principal associate in Evershed's litigation team with a particular specialism in technology, AI, and privacy.
Chloe, let's go to you next.
Hi, I'm Chloe Themistocleous. I'm a partner in our UK employment team. I mainly specialise in employment tribunal litigation, and I also sit as an employment tribunal judge in the UK. I've got lots of expertise and experience in supporting global clients building legally compliant AI solutions for HR, and I've been thinking through a lot of the issues that we're going to talk about with that client perspective for quite some time now.
And last but not least, Deepa.
Thank you, Hannah. Hi, I'm Deepa Menon. I'm a partner in the Evershed's US team. I sit in Washington, D.C., and I specialize in employment law and also in privacy and data protection laws. And I have a particular focus on helping companies tackle AI and privacy issues in the workplace.
Great, thanks, Deepa. As AI becomes more intuitive and embedded into workflows, it's important to recognise that sharing privileged information with these systems, including chatbots and document management tools, could risk the loss of waiver of legal privilege in some circumstances. In this episode, we'll look at how the growing use of AI is raising new questions about legal privilege and discuss the practical challenges employers encounter as they adapt to these technologies in real-world settings. So, Matt, could you start us off with a quick refresher on what legal privilege is, why it's so important, and how the concept varies across jurisdictions?
Thanks, Hannah. So most, if not all, legal systems recognise that communications between a person and their lawyer should be kept confidential. And the reasons for that are pretty obvious. There's obviously a general public interest in ensuring that people are able to obtain legal advice. And it's difficult to imagine how anyone could instruct a lawyer and take legal advice if they didn't feel able to discuss their case fully, frankly, and openly with that lawyer, and without fear of those communications being used against them, and without the risk that they might be ordered to disclose those communications to an opponent or a court in the course of litigation. Now, pretty much every legal system shares that general principle that people have to be able to communicate confidentially about their case, but every jurisdiction has a different approach to how that communication confidentiality is protected. Generally speaking, jurisdictions that have a legal system derived to some extent from English common law, so just to take some examples, the UK, Canada, Australia, the United States, tend to have a broadly similar concept of legal privilege. This is partly because common law jurisdictions tend to have an adversarial court process with a disclosure or discovery process, by which I mean, as part of the dispute resolution process, the court will generally direct the parties to search for undisclosed documents to the other parties, and the other parties could obtain an order requiring certain documents to be provided to them, which otherwise would be kept confidential to a party. In other legal traditions, so for example, European systems founded in more of a civil law tradition, there often isn't a directly analogous concept of legal privilege, but generally speaking, they do have a related concept of sort of professional secrecy or confidentiality. So, for example, France and Germany, neither of them has legal professional privilege in the same way that England or the United States would do, but there are rules and procedures that protect the confidentiality of lawyer-client communications, and they fulfill a similar function within their legal system. But for in-house teams, and particularly those operating across multiple jurisdictions, privilege has always been a pretty difficult area to manage, precisely because it's both really important and really different between the different jurisdictions one might be operating in. So there are inevitably going to be challenges in ensuring that privilege is being protected when the lawyers and those receiving or seeking legal advice are in different jurisdictions with different approaches to privilege, or even the concept of privilege. And that extends even to which lawyers can claim it at all. So, for example, in the UK, Generally speaking, advice from an in-house lawyer can attract legal privilege, but generally in other European jurisdictions, so to stick with France and Germany as examples, those confidentiality rules, the analogous confidentiality rules, don't apply in the same way to in-house lawyers as they do to outside counsel. And all of this, taken together with the adoption of AI tools by in-house teams and businesses in connection with work that might ordinarily have been done by a lawyer, is really the new frontier of these difficult questions for privilege. And that's why we thought this was a good topic for us to discuss today.
Great, thanks, Matt. That's a really clear and helpful refresher on privilege. Now, Deepa, you've been seeing some pretty interesting developments in the US. Perhaps you could talk us through some of those?
Sure, Hannah. Thank you. And thanks, Matt, for that overview. The thing about the United States is we're forever ready for litigation in a way that other jurisdictions probably aren't. And so obviously for us, legal privilege is a huge driver in the kind of choices employers are making, both on the technology front and just in terms of procedures and policies. Now, one thing that we're seeing in the US is, and I'm sure this is not specific to the United States, but employers are grappling with innovation and spend. So employers want to use AI for operational efficiency, but there's still the whole cap on spending, especially in today's current economic times. And what we then see is that companies or employees will go ahead and use public AI models to test value. And now an enterprise model comes with all the bells and the whistles, the confidentialities and the guarantees that the data will not be used to train the AI model. Public models don't come with the same guarantees. So what we then see is that when employers don't roll out enterprise level AI models within the business, employees will continue to use AI, but then look to public models. And then you just, all of a sudden, no one's really paying attention to what the vendor's promising. No one's talking about how the data is being handled, whether confidentiality will be maintained. And as such, when you don't have those safeguards, you have real risk that privilege is going to get blown. Another place where we see privilege becoming something of a concern is with tools like chat boxes or with employee listening programs, third-party vendors. Now, just to kind of give you a scenario, think about a sensitive internal legal call and someone's decided they're going to record and transcribe the call. Now, often these tools, the transcription and recording tools, are being run by third-party vendors. And it's possible that the third-party vendor provides the recording service, but then uses a subcontractor for the transcription part of it. And the company may not have thought about whether the subcontractor is still bound by the same confidentiality or agent terms. And now what you have is a scenario where potentially the transcription or the transcript is now available because it's discoverable because it just doesn't have the same protection to it as you would have if you had a vendor who was bound by all these terms and conditions that clearly clarify that they're actually an agent of the lawyer. So and in any scenario, you kind of think about vendor contracts, and that's really the big smoking gun. For example, if you have an employee who's going to upload a contract that was marked up by an attorney, generally that would be protected under the work product doctrine that would be considered covered by attorney-client privilege. But now the employee goes ahead and uploads the contract, which has the lawyer's comments, into a cloud-based editing tool. Now, the problem here is the vendor's contract doesn't specify the confidentiality terms or the conditions, and also may not specify whether the data can be used to train the AI model. But once again, you land up in the same position because you may be blowing privilege with respect to that work product. So it is just generally, kind of to recap, what we're seeing is really two pieces. One is with the public AI models, and two is with insufficient protections laid out in the vendor contracts, or no protections laid out in the vendor contracts. And now, of course, you have chatbots, and there's the risk that an employee is going to input things into this chatbot, which again leads to a waiver of privilege.
Thanks, Deepa. Some really interesting points you've raised there. So now, Chloe, just to develop this a bit further and coming to you, I know you've been looking in particular at the issues of employees putting information into workplace chatbots, and you and Matt have been working on some of these issues together. Do you want to perhaps tell us what you've been seeing and the particular challenges that have been raised around legal privilege?
Sure, thanks, Hannah. I think one thing that's really clear is that a lot of our clients and businesses that we're speaking to are telling their employees, we need to be more efficient. We need to embrace AI, but not all of them have a good infrastructure as to how that will work in practice. And that can lead to a lot of issues, especially in relation to legal privilege. So I think one of the scenarios I'm seeing a lot is where individuals are using chatbots. Perhaps employers have encouraged that use, but without that necessary framework and the parameters around that usage as to when it should be used, how it should be used, what supervision protocol perhaps there is. So giving an example that, without those guardrails, you could, for instance, in an employment type scenario, have a HR point of contact essentially engaging with a chatbot, whether it be one that's produced by a business internally or whether it's one that's kind of on the main market, and asking it things that could be akin to what they'd ordinarily ask a legal advisor, and forgetting that they don't have that same privilege when a lawyer is not in the loop. So asking questions regarding how do we terminate Joe Bloggs? Will Joe Bloggs' termination be fair? And, both the question that's been asked and the output that's given doesn't necessarily have any privilege. So in terms of if those documents or if the information that's been created is ever requested in terms of a litigation exercise, so disclosure or DSAR, you could end up surfacing some material that's pretty damaging. Matt, I know we spoke about whether or not there were any ways around this, and I'm keen to get your input on what you're seeing on this as well.
Yeah, absolutely. Thanks, Chloe. I think the thing that people forget when they're dealing with new technology is that the existence of a new piece of technology doesn't change the way the law already fundamentally works. And looking at this particularly from the perspective of an English lawyer or frankly, by extension, a common lawyer, law in the common law doesn't come in a vacuum. Law evolves from pre-existing law. So when we take something like an AI chatbot, which on one level is a pretty new technology and a pretty revolutionary thing to have available, what the courts do is not look at that and decide what the rules ought to be based on the technology itself. They look at it and say, well, by analogy to existing law, how does this fit with what we already do and what we already use as our approach to different things? So often, because I do technology litigation, very often we're looking at products and services that didn't exist when most of this law was kind of put in place, but you are working out how the existing law applies to that. So with something like a chatbot, there's an automatic kind of feeling that, well, this thing is producing something that is akin to legal advice. It's producing something that is in substance an explanation of what the law might be. So if I, for example, type into a chatbot, how do I fire Dave without getting a wrongful dismissal claim, for example, what I get back out of the chatbot might be something that in substance looks like legal advice. But the way that privilege works, and taking the UK as an example, in the UK, for something to be privileged, it has to fall within one of two general categories for the most part. The first is that it has to be legal advice, and that means it has to be a communication that's passing between a lawyer and their clients, and the dominant purpose of that communication has to be legal advice. Or it has to be something that is passing between either the lawyer and the client, or the client and a third party, or the lawyer and a third party, but where the dominant purpose of that document is litigation that's actual or contemplated. And in both cases, the communication has to be confidential. So if you take those as the basic principles and you look at something like a chatbot, well, if we assume that there's no litigation happening and there's no dispute on foot, this is just general run-of-the-mill, business as usual legal question. Well, if a non-legally qualified person types in a request to a chatbot, which is a chatbot, is not a lawyer, whatever that chatbot outputs, there is no communication there between a lawyer and a client. So legal advice privilege just on a sort of definitional level cannot apply. So that means that whatever's coming out of that chatbot, it is on basic principles quite difficult to see how you could ever cloak that in privilege outside possibly of a litigation context, because there is no lawyer in the loop, so to speak. So it's a complicated technology, but actually applying the basic principles to it, it's not that complicated to work through and say, well, hang on a second, this thing which is capable of giving something which might be substituted for legal advice isn't really a lawyer, and so very arguably whatever it puts out is not privileged and would be disclosable in litigation.
So interesting, Matt. Thanks for sharing that. Taking it a little bit further, because I'm always pushing the boundaries. I've had other clients and seen other businesses wanting to be more efficient in almost like regurgitating and reusing information they already have in their system, whether or not that might be questions they've previously asked lawyers or draft letters that lawyers have previously input on. What happens to that privilege given under one piece of advice if it's churned out by an AI tool in a different context?
So again, looking at this from an English law perspective, the way that legal advice works, particularly with a large corporate organization, is that the advice that's being given by outside counsel or the in-house counsel to the business, for the purposes of that advice and for the purposes of legal advice privilege in that advice, the client, for the purposes of that relationship, the lawyer-client relationship, is not the business as a whole. The client is, and I'm sort of grossly simplifying here because it's one of those surprisingly complicated areas of law in England and Wales. But the client is effectively the specific people within the business who have been tasked by the business with seeking and obtaining that legal advice. So if I have, say, an advice note on my file system that was obtained by, say, 3 different employees from an outside counsel, and I am then wanting to share that document internally with people who are outside that client, there are sort of precautions and steps you need to take to make sure that confidentiality isn't lost. Because the crucial component of legal advice privilege is that the advice itself must remain confidential, and it must remain confidential as between the lawyer and the client. So where the client is effectively specific people within the business who were permitted to get that legal advice, but the advice is then shared with other people within the business. There have been quite a lot of high-profile cases, in fact, some of which this firm was involved in, where we've been having fights over whether or not documents retain their privilege in circumstances where they're shared outside of that inner client. And so if you're using the existing legal advice to sort of fuel a chatbot or feed training data, it's not a question that I think well, as far as I'm aware, and I'm confident of this, no court's ever really made any kind of determination about those specific facts, but just applying the basic principles. Well, if I stick all that advice into a chatbot and feed a generative AI with that data, and it's then producing something derived from that data, what is the privilege status of the documents I fed into it? Are they still confidential? And if they're not confidential, again, as regards that kind of specific people, the inner client and the outside counsel, arguably legal advice privilege can't exist anymore because it's not confidential anymore. So it's not a straightforward question because it's not a straightforward answer, because ultimately it kind of depends on a really specific look at how does this system work? What exactly is it doing with the advice? How is it outputting it? And on a sort of technical analysis, is it still confidential? And I think that certainly in my experience, I've seen a lot of clients looking at these products and not thinking in these kind of analytical terms about the risks that come from using them. And it's not that any of these risks can't be surmounted, that they absolutely can be, I think. It's going in with the right mentality of saying we need to do this in the right way and make sure that we're not inadvertently creating a huge problem for ourselves down the line.
I think the more we talk about this, Matt, and the more we scratch the surface, the more complex the issue becomes. Another issue that we're seeing a lot in the employment team at the moment is really long, unwieldy grievances or claim forms being produced by employees or former employees that we would say have clearly been produced by AI, because you'll have individuals with very little employment law knowledge quoting bits of case law that I've perhaps never even looked at, or in some instances that don't even exist. And we're having clients, or we're seeing clients wanting to use AI to help respond to those long grievances and claim forms. And I suppose we've touched upon this a little bit already, like using AI tools for the purpose of, assisting in responding both pre-litigation and litigation. But I just wondered kind of what your thoughts were, and it probably goes back to those basic principles in terms of, what about all the drafts that are produced, the various iterations that are produced? Is there a discussion about retention of this information that could be problematic for clients as well?
Yeah, absolutely. I think there is a real risk that if to the extent that you're using generative AI tools, you are creating documents which otherwise wouldn't exist, which might not be privileged, and that's just a risk that exists. Now, it's less likely to be an issue where there is litigation or some kind of adversarial court process that is genuinely in contemplation or in prospect. So if someone is writing to you threatening a claim and you're using generative AI as part of your sort of decision making for responding, that's probably a safer situation than some others because litigation privilege, as we talked about earlier, is a lot more permissive than legal advice privilege. But if there's no litigation in contemplation and you're using these tools to help you generate sort of drafting, potentially what's being produced and what's being put into it might be disclosable. And it will be a similar kind of analysis to any of your sort of working papers or internal documentation that you're producing. I think the key risk with using something like a Gen AI for that kind of purpose is, generally speaking, if you've got, say, a Word document, that Word document gets edited and amended over time. And by the time you've got a finished document, you may have a couple of earlier versions, but you probably only have you may only have the one final document that you've been working in the whole way through. With generative AI, because you're putting in different prompts, you're checking the prompts, you're engineering prompts, you're checking the output, you're feeding back in again. That iterative process means that depending how you're using it, you could well be producing vast quantities of additional documentation that wouldn't otherwise exist. And it's easier to do that without really thinking about it, I think, with these tools. And I think that's a thing to sort of have in the back of your mind as a problem. But the wider issue again is if you've got people in the business who have access to these tools and they're able to use them, they are going to use them to be blunt, and they're going to use them for things that you're not expecting them to use them for. So it's too early days to have really seen this happen yet in litigation, but I think very soon we are going to start seeing disclosure exercises where we're finding and having to look at generative AI inputs and outputs and decide whether or not they're privileged. And you mentioned earlier, clients receiving AI generated communications from litigants. We are seeing that. Certainly when we have matters where litigants in person are involved, we're seeing large volumes now of communications that are clearly generated by generative AI. And the danger there for everybody involved is that they do hallucinate. And to a large extent, particularly in a specialist context, if you're using a generative AI to produce legal correspondence, it's relatively straightforward for a lawyer to do that, because if I use an AI to help me draft something, I know enough about the underlying law to know whether or not what he's telling me is correct, or to sort of sense check it. And it's much easier for me to work out where any problems are because I can kind of see it. Whereas if you're not legally qualified and you're not used to drafting that kind of thing, if ChatGPT or whatever Gen AI you're using tells you, oh yeah, this case supports your argument. Well, if that case doesn't exist, I as a lawyer have the tools to figure that out. I have access to the databases. I know what a citation looks like. I know, I know, generally speaking, what the case law is in the area that I'm working in. Whereas if you are just a general member of the public without the legal background, it's very convincing, and it's quite difficult for you to tell even that something isn't real, because it may just be that it is real and you just can't find any source or have access to any source that will tell you otherwise. So we're seeing it a lot. I think it's potentially quite dangerous to use without that sort of qualification to allow you to understand what's going on, because you haven't got the background. But it's also, yeah, it is something that is a challenge for clients, because it's much easier, I think, to put together a claim or put together a letter complaining or raising an issue if you don't have to do the legwork of drafting it yourself.
I think we all need to kind of adapt our ways of working, but we're in a really interesting time at the moment where we've got so many different tools that we can use. And it's really about picking the right ones and having appropriate guardrails. And on that note, I'll pass back to Hannah to do some reflections.
Great, thanks both. I mean, I think it's fair to say, with so many aspects for employers to consider when rolling out new AI tools, the issue of legal privilege perhaps isn't always thoroughly considered. And certainly, you know, when we listen to the discussion that Chloe and Matt, you guys have just had, but clearly it's a really important risk for employers to think through, and one that they need to be on the front foot of, not the back foot, particularly if litigation is contemplated. So with that in mind, I think what would be really useful, given all the very interesting, thought-provoking points we've been discussing today, would be to wrap up our discussion with sort of 3 top tips for employers to consider when deploying new AI systems in order to safeguard legal privilege. And perhaps just to keep it even, we could have a tip from each member of the panel. So Matt, can we start with you?
Thanks, Anna. Absolutely. I think the key for me is understanding how the system works. So how is it using data? What data is going into it? What is it outputting? How is it storing that data? That's the important thing. It's not complicated. It's the same kinds of questions you'd be asking about, frankly, any technology system that you'd be procuring or using. And it's fundamentally understanding what it is that you are using and how that thing works.
So Chloe, shall we go to you for tip number 2?
Thank you. I feel like my tip's in 3 parts, so apologies for that. I think we need clear policies. So how you should be using AI tools, in what circumstances, what supervision protocol there is around them. And then there needs to be a governance infrastructure to make sure that what you're saying should be followed actually is being followed in practice. And then training as well, training your people on how to use it. This is completely new. Some people will adopt AI really easily and others won't. So making sure you've got that base level of training is really, really important. Thanks, Hannah.
Great, thanks, Chloe. And then Deepa, just coming to you for the last and final top tip.
Yeah, I would say again, vendor contracts. We need to be thinking about what safeguards are in those contracts, and also thinking one step further. What happens if privilege is waived? What happens if something becomes discoverable? There's going to be some damage or some liability that could come out of that waiver. Who holds the bucket if there were to be such a waiver? I think those terms need to be teased out in the contract, so you're not just thinking about privilege, but also the liability bucket that follows if a privilege is waived.
Thanks, Deepa, and thanks, everyone. 3 really clear and helpful top tips there. So all that remains for me to say is thanks so much for tuning in. We really hope you enjoyed today's discussion. Please join us next time for more AI insights and conversations.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.